Question 18. What is dischargeable and what is not dischargeable in bankruptcy? When you receive your discharge notice, like it is right here, it's very simple. It reads, it appearing that the debtor is entitled to a discharge, it is ordered the debtor is granted a discharge under Section 727 of Title 11, United States Code, the Bankruptcy Code, signed by the judge. So this is very, very brief and to the point. On the back of your discharge, it reads that the collection of discharged debts, any attempt to collect on those debts, is prohibited, and that most debts are discharged. It also says that if a lien hasn't been avoided or eliminated in the bankruptcy, by a creditor can still enforce its rights under that lien. It does not itemize or list the debts which have been discharged in your particular case. You have to turn to 11 U.S.C. Section 523, entitled Exceptions to Discharge. You can find a list of what is not discharged in the Chapter 7 or Chapter 13 case. According to the way the code is written, it says what isn't discharged and simply says everything which is not accepted from the discharge is dischargeable. The Bankruptcy Code defines what is dischargeable by negatively backing into the answer. If you think that's convoluted, try reading the code itself. I assure you, you have to have a flow chart to understand what it is trying to say, and it has taken me years to break through some of the most convoluted language ever devised by man. And you always have to be aware that there's some exception or refinement to almost every rule that's lurking in the shadows. Now here goes. I'm going to tell you what is not dischargeable in bankruptcy. 1, taxes aren't dischargeable unless they meet certain criteria and are a certain type of tax. I have talked about this previously. On the back of your discharge, notice it says here regarding taxes, it simply reads debts for most taxes, which it makes it sound pretty hopeless. 2, debts incurred to pay non-dischargeable taxes are non-dischargeable. There was a very quiet amendment to the Bankruptcy Code which states that when you use a credit card to pay a tax, then that credit card debt is non-dischargeable. This is a real sleeper of an exception to discharge, but I assure you that it's more complicated than what I can discuss on this video. Another one, number 3, debts incurred by false pretenses, false representation, or actual fraud, non-dischargeable. Number 4, for fraud, defalcation while acting in a fiduciary capacity, embezzlement or larceny. Number 5, debts incurred in the amount of $500 for luxury goods or services incurred 90 days before you file your bankruptcy petition. As an aside here, I have developed a special form exactly for this radar trap, which was planted by the credit card industry. Here it is. I call this form my radar form, and it's invaluable in helping the consumer become organized to answer certain specific questions regarding this issue. I absolutely insist that clients properly fill out this form before I render any opinion as to whether or not they can safely file a bankruptcy petition. One young man told me that he went to another lawyer and he didn't require that he fill out time-consuming forms. I simply told the young man that perhaps he would just as well work with the other lawyer because I wouldn't represent him. I told him there are 2 types of pilots, A and B. Pilot B is very cavalier. Pilot A checks everything many times before landing. I told him, I'm Pilot A. I make no apologies. If I can win through thorough preparation, that's exactly the way I do it. Number 6, a cash advance of more than $750 taken 70 days before you file a bankruptcy petition is non-dischargeable. Number 7, for a domestic support obligation. Alimony and child support are non-dischargeable. Number 8, causing willful and malicious injury to another or to someone's property are not dischargeable. Debts for most fines, penalties, forfeitures owed to the government or criminal restitution are not dischargeable. Student loans are not dischargeable unless there's a hardship. And don't forget what I previously told you about what constitutes a hardship. Number 11, debts which were incurred while you were, because you killed or hurt someone due to the operation of a motor vehicle, a vessel, or aircraft while under the influence of alcohol or drugs are non-dischargeable. An interesting aside, a man was operating a motor vehicle while intoxicated and drove into someone's house and caused damage to the house. Was the debt incurred because of the damage to the house dischargeable? Answer, yes, it was discharged because he didn't do any damage to the owner of the premises personally or anyone else. Number 12, debts to a spouse, former spouse, or child that is incurred in the course of a divorce or separation or in connection with a separation agreement, divorce decree, or other order of the court of record, or a determination made in accordance with state or territorial law by a governmental unit are non-dischargeable. 13, debts for support payments owed to the state or municipality which come under the Social Security Act are not dischargeable. 14, condo fees incurred after you file for bankruptcy are not dischargeable. 15, debts owed to certain pension, profit sharing, stock bonus, or other retirement plans, or to the thrift savings plan for federal employees for certain types of loans from these plans are non-dischargeable. And 16, debts which the bankruptcy court has specifically ruled are non-dischargeable are, of course, non-dischargeable. Now, the above list can give you a general idea as to what is non-dischargeable in bankruptcy, but for every rule there is usually an exception, and the facts of your particular case have to be analyzed by an attorney before you can conclusively know what is dischargeable in your particular case.